I saw a video the other day about 7 ways to avoid probate without a trust. And I get why people watch those. Because probate scares people. It's slow, it's public, it can take over a year. It can cost thousands, tens of thousands, sometimes way more, and it happens at the worst possible time. Your family's grieving, now they're in court. But here's the problem. The entire conversation is built on the wrong question. How do I avoid probate? That's not the real question. And if you built your plan around that question, you can actually make things worse. The cure can be worse than the disease. Because the real questions are, what happens if I'm alive, but I can't make decisions for myself? What happens if my kids don't agree and they don't get along? What happens if one of them gets sued or divorced, or they start fighting with the rest of the family? What happens if I accidentally create a tax problem? And most importantly, what happens to my family when I'm not there to fix problems? Because I've seen what happens when people don't plan. And it's not theoretical. We sometimes see this stuff play out in the news. Remember when Prince died? He had an estate worth hundreds of millions, but he had no trust, no plan. And what happened wasn't just a probate, it was years of court battles, family members fighting, coming out of the woodwork, millions in legal fees, and everything became public. Every asset, every disagreement, every detail. Dirty laundry. Now here's the part people miss. Prince didn't have a probate problem. He had a planning problem. And that's what most of these avoid probate videos miss. They give you tricks, but they don't give you a system. So today I'm going to walk you through the 7 most common probate avoidance tricks, show you where they break and explain what you should be doing instead. Before we get into the list, I want you to think about this differently though. Every strategy should really answer, let's say, 4 questions. Does it avoid probate? Do you maintain control while you're alive? Do you still have control of your estate? Even are you directing someone to act on your behalf even if you are alive? Does it protect your beneficiaries? And does it preserve tax advantages? If it doesn't check those 4 boxes, it's not a plan, it's a shortcut. And shortcuts, let's be real, that's where families get hurt. So the number 1 is gifting. This is gifting your assets before you die. And this sounds simple. Just give everything to the kids now. No probate, done. Let me show you how this actually plays out. Dad gives his house to his son. Everything seems fine until the son gets married, then divorced. Now the house is part of that fight. Or worse, the son gets sued. Now the house is exposed to creditors. Maybe the son is just lazy and decides to sell the house. Well, what if dad actually wanted to live in the house? Whoops. And here's the kicker most people don't see. Taxes. Dad bought the house for $200,000. Now it's worth $800,000. He gifts the house to his kid. The son gets a $200,000 basis, what he paid for it. Not what it's worth, what he paid for it. Then it gets sold. When it gets sold, now they owe tax on $600,000. What if the kid had inherited it instead after dad passes? The tax would literally disappear because of something called a step up in basis. So what do we do now? We avoided probate and we created a 6-figure tax problem. Oosh. Number 2, and this is for your parents out there, it's adding your kids to your properties. This is where you're adding them as joint tenancy. And this is one of the most common mistakes I see. And it usually comes with really good intentions. I just want to make things easy. But they add their child to title. Now let me tell you what happens next. I had a situation where a parent did exactly this. They added their daughter to the home. Daughter gets into a lawsuit, and suddenly that house is part of the conversation. The parent is shocked. They thought that they were protecting their house by adding their daughter on. They didn't realize that they literally just exposed it, because legally, well, the kid owns part of it, that house. So now you've added another person's, your child's, liability to your home. Now their lawsuits matter. If they get divorced, it matters. If they go bankrupt, it matters. You didn't just avoid probate. You brought your child's financial life right into your home. Number 3, naming beneficiaries on everything. I'm just going to say naming bennies, right? This one's actually very powerful, excuse me, but only if it's coordinated. And most of the time, it's not. And let me give you a real life scenario. Mom has 3 kids. Her trust says, divide everything equally. Her retirement account has a beneficiary designation. She lists the eldest child. She never updates it. The child gets everything. So you can already kind of guess what happens, right? That one child gets the entirety of the retirement account, and the others get nothing. And now you don't have an estate plan. You have 3 kids that are going to be fighting with each other. And I've seen this tear families apart because the paperwork overrides the intent in that situation. And beyond that, what if the beneficiary is 18 or younger? What if they're horrible with money? What if they're an addict, they're dealing with drugs or alcohol? What if they're on government benefits? Maybe it's not the type you think about. Maybe it's not something where, hey, it's because they're not making enough money, but maybe it's they have special needs. You just handed them everything with no protection. And in every situation I just listed out, you could be exposing that money to third parties. Number 4, transfer on death deeds. Call it a TOD, transfer on death. These are marketed as simple solutions. Add a name, avoid probate. Great, until something goes wrong. Say you have 2 kids, they don't get along, you pass. Now they co-own the house. One wants to sell, one doesn't. Now what? Or worse, you're alive and you're incapacitated. Who's managing that property? This tool works perfectly in one moment, and that moment is at death. But life doesn't work that way. What if they predecease you? What if they have a mess of a financial life? What if they have addictions? They have bad marriages. You know, you get the idea. You just made a mess. The avoid probate trick, it's a little more complicated than just saying, hey, I'm just going to list it on a TOD and transfer on death. Number 5, LLCs and corporations. I'm going to say LLCs and corps. This one gets pushed a lot online. We love them, by the way. But you put it in an LLC, problem solved, right? No, that's not how it works, because that's not what an LLC is really for. An LLC is for liability protection. It's literally its name. It's limited liability company. It can also be great for privacy. Like, we love to get your name out of the public record. An LLC can be great for that. You can have anonymous ownership of LLCs. It can protect you from your assets that are risk-creating assets like businesses, rental real estate, and things like that, and your assets from you. So I could put my brokerage account in an LLC and it protects it. Like if I get into a car accident, if I use a state like Wyoming, I can literally protect it. But an LLC is not an estate plan. And here's where people get burned. They move their home into an LLC to avoid probate. And if they die owning the LLC interest personally, they're a member, that interest still goes through probate. Now they've added complexity and they didn't even solve the problem. Make sure you're talking to someone who knows what they're doing so that you don't fall into this trap. Number 6, charitable planning. I'm just going to say charities. And I'm going to go over the right way to use them and the wrong way. Most people talk about this wrong. They say, give your house to charity, live in it, avoid probate. That's one way, but it's rigid. You can't change your mind, right? So let me show you a better way. I've worked with families who create their own charitable foundations, and they start giving while they're alive. They get tax benefits now. And it also removes the asset from their estate. And they avoid probate on those assets that are now in the foundation. But here's the part that I love the most. They bring their kids into it. They teach them how to evaluate financial opportunities, how to make decisions for the foundation, and then how to give intentionally. Now, when the wealth transfers, the kids aren't guessing what to do with it. They're prepared. They're not just doing regular old planning. This is creating a legacy. And for those of you worried about money, hey, what do I do if I need the money? Or what if my kids need the money? They can still take a salary just as you can from that foundation. So why do all the rich folks seem to have a family foundation? Well, this is why, because there are real benefits. But you need someone who knows this stuff to guide you. And this is part of a plan. This isn't a lark. This is something that you do very intentionally, and you work with somebody who knows these rules. And I'll give you how to work with somebody here towards the end. Number 7, small estates. I hear this all the time. My state has a small estate statute. This one sounds easy. Your estate is so small, you can skip probate. And that's not how it works. It's just you get a lighter version. You get a lighter version of the probate in some cases. It's still court. It's still paperwork, and there's still delay. There's statutory requirements on things like real estate, for example. This is the state saying, hey, because it's so small, we'll process your stuff faster, which is very relative. It's for very small estates, and it still costs money. Let me give you an example. I had a client who inherited one property in a estate. It was a $300,000 condo with a mortgage. It was mortgaged fairly extensively. One home, not a ton of equity to probate. And it sounds simple, right? Well, the attorney's fees on a standard schedule were $13,000 on that one piece of property. And then you say, well, what about the small probate? It doesn't really matter a lot of the time. And in this particular case, they didn't live in the estate, and it was moot. Right? You can, if you have a tiny estate, like, hey, I'm talking about less than 50 grand, and the deceased lives in your town, you might be looking at a slightly different story. But if there's real estate involved or anything else, like, it's out the door. You get the idea. No matter what, this small estate is still not part of a plan. Remember the 4 things I went over? It's not going to help you until you're past, and then you're hoping that you're going to avoid probate. You still may be under state law, and you're dealing with a bunch of nonsense that you could completely avoid. Now, I'm going to go over a few honorable mentions that I hear a lot. So I know that in the comments below, I'm going to get somebody saying, what about ladybird deeds? Yes, they can be useful under certain circumstances. They let you keep control during your life and transfer property at death. And it's better than some of the basic shortcuts, but they're still limited. They don't coordinate with your full estate. They don't protect beneficiaries. They don't solve incapacity planning. So they're still a good tool, but they're not a plan. What about the people that say, but I have a will? I've already done my planning. I have a will. A will guarantees probate. You will go through probate with a will, and that's what it does. Or this is the one that drives me absolutely nuts. Hey, my family will figure it out. I'm not worried, my family. They all get along. They'll figure it out. Yeah, they will in court while grieving and paying lawyers. And I've watched families go from being very close to not speaking anymore because of this type of poor planning. Because grief and money are combustible. You're throwing a lawyer into grief and money is like throwing a match into a dry stack of wood soaked with gasoline. It's going to go boom. Now, what do you actually do? And this is what I actually teach. I stopped asking, how do I avoid probate? And I started asking, How do I build a system that works if I'm alive and incapacitated? How do I build a system that works if I'm gone? I want a system that works under both circumstances. It controls my stuff during my lifetime. It protects my family from all sorts of different, like I don't want the conflict, but I also don't want to create a problem for them. Like if you have special needs, grandchild, and you give a bunch of money to them, the state's just going to take it, the municipality's going to take it, and they're probably going to lose benefits. Oops. You want coordination across all of your assets. You want tax efficiency. And yes, you still want to avoid probate. And that's why, for most people, a properly structured living trust is going to be the win, because it solves multiple problems at once. Avoiding probate is easy. Avoiding probate without creating a bigger problem is not so easy. And that's why they call it estate planning. It's not just, oh, boom, I'm just going to do this. And that's really what most people miss. So what I'm going to do here is I'm going to point you in the right direction to learn more. But first, if you know somebody trying to piece this together with shortcuts, the 7 shortcuts right here, send them this video so at least their eyes are open. And if you can, drop a comment below. What is your biggest question that comes out of this about estate planning right now? And it could be asking for somebody else. I don't care. Just put it down in the comments. It's fun to see what everybody is kind of thinking, and it helps me create more content when I start seeing the same questions popping up. And by the way, on this channel, if you're not subscribed, please subscribe, because I break down tax strategies, asset protection, how to preserve, protect, and prosper. I do these like usually 2 or 3 videos a week, and so if you subscribe, you'll see them. Now, before you go, I've got 2 free resources for you. First, I did an estate planning 101 workshop where we walk you through how to actually build this system, and we do it absolutely free. I even give you a downloadable emergency binder and go over it with you so that you can get halfway home absolutely free. You can make sure that your estate plan isn't just something done, hey, I've done this. You're creating something right from the get-go, and there's no cost to it, so there's no excuse. I'll put a link there for you so you can get that. Second, you can schedule a free one-on-one session with an Anderson advisor. There's no pressure, just answer. So you can ask all the questions that relate to you and say, is this something you even want to do? Both links are in the description below. Both are free. Good luck. God bless.